Hello? I'm unable to hear you. No audio. One moment. Just one moment, please. For whatever reason, I have no audio. I can't hear you. Can you hear me? Well, what the heck? Just one moment. Can you hear me now? Okay, well, for whatever reason on this PC, I'm unable to hear you. But if you can hear me, that's a yes. So Your Honor, you are able to hear me? Your Honor? Oh,
Am I being heard?
that's what I'm trying to figure out. I can't hear him. I don't know if he can hear me.
I can hear you, Travis. I can hear Travis. I can't hear the judge.
Exactly, same thing. I can hear Bretta. I can't hear the judge. Please shut my door. Please shut my door. Okay.
Okay. Can you hear me now, ma'am?
I can hear you, Judge.
What is your name?
Bretta Hughes.
Oh, good. I got the right one.
Yay!
Do you happen to know Mr. Short's phone number? Because I'm not
I can
picking
hear you
him up.
now.
Ah, wonderful. Technology is a wonderful thing when it works.
Yes, it is.
Okay. So we're here on Ms. Hughes' parenting time complaints. According to the complaint, you showed up on Sunday at 6 p.m. To pick up your, is it your son? Yes. And Mr. Short did not allow him to go with you, is that correct?
He did not allow any of the children to go with me, the older three.
And I'm sorry. Oh, okay, that's right. We've got Turner, Kaylee, Cadence.
And that's it. Just
And
those three for now. Tegan's not involved in any of it.
right, Tegan, sole custody with you, supervised parenting time with his father.
Correct.
All right, give me a moment. I did a de novo custody hearing and basically restored the consent custody order that the two of you entered back sometime last year. So what's supposed to be happening is week on, week off parenting time, correct?
Correct.
And you're telling me that's not happening?
Correct.
Mr. Short, why isn't it happening?
Well, I've got a list of reasons why it's not happening, Your Honor. To start off with, I've never received anything from the court saying that I missed a court date, that I had another court date coming, or that custody has changed at this address. I know in the past, Ms. Hughes has been able to start these motions with friend of the court and and have the responsibility on her part to put down my correct address and everything else to
All right,
make sure I
hold
get
on a
these
minute. What is your current address?
318 Johnson Street. I've been here since March. But for whatever reason, I have still, to this day, received nothing saying that there was any change in the order, that anything happened.
I have
How long-
signed, stamped,
hold on,
certified mail.
hold on a minute, ma'am.
Yep.
How long have you been at your current address, sir?
Since the end of March.
All right, well, the order that I did was sent 708 West Ganson Street.
See, that's
didn't
my,
get.
I never received anything like that. That's my previous address.
It says care of Banfield. What does that mean?
That's the roommate that I was living with at that last address.
All right, so 3810 Johnson Street, 49201?
Yeah, 318 Johnson Street, Jackson, Michigan, 49203. This notice that I just received yesterday was the first piece of mail I've received here from the court.
All right, so I get that you didn't get that order. That order was entered as a result of a hearing I held that you were present at. After objections were made to the referee's recommendation. You both were present at that hearing. Looks like it was May 21st is when I held that hearing.
Yes.
And I listened to the objections. I asked either of you if you had any issues with the referee's evidentiary findings, and you didn't identify any significant issues. And I told you that what I would do is review the referee's factual findings and make an independent decision on the issues presented. And I did that. And I explained all of this in my order after that de novo hearing. The end result of that was I found that the referee shouldn't have changed the order that you two entered into by stipulation back in July 31. of 2019, and I restored that arrangement. So what I'm going to do, sir, is I'm going to make sure you get a copy of this sent to your address, and I expect it to be followed.
Okay, can I add in a little bit more here, Your Honor?
Go ahead.
There's been a big development. On approximately July 15th, Turner, our oldest child, indicated to me that the last time he was with his mother, they were taking a trip up north. And during this trip, while going down the highway, she and two other adult individuals smoked marijuana while going down the road on the highway. Now, this was very, very, very nerve-wracking to learn. And upon farther talking to Turner, he said this has happened multiple times, so numerous that he doesn't even know. Sometimes it's a small trip across town to his grandmother's house. She has to smoke marijuana while driving. There's a lot of different factors here, Your Honor, that's the main reason I have not followed this order that's changed. Greta said it's changed. I never received anything saying it. And once Turner told me that she's literally getting high while driving with the kids in the car, I feel it's my duty as their father. I'm the one that's had custody since 2013. I'm the one that's kept them safe. It's my duty as their father to keep them safe. I know he's not lying. She's just going to call him a liar. I can bring Turner in here right now to back up what I'm saying. She's just going to call him a liar. I'm doing what I have to do to keep them safe, Your Honor. She should have no custody of these kids. This has always been about child support. She does not want to have to pay me child support. Because, for instance, in 2015, she had child support lowered from $90 a week to around $50, with the stipulation that she was going to pick them up after school every single day. Your Honor, in 2 years, she never picked them up from school once. It took literally 3 years later for her to start picking them up from school. Literally, she's been paying something like $40 during those 2 years. It was like $40 a week in child support, which I almost never received. And she never even picked them up from school. This is all simply about being from under that axe that she sees child support as. I'm currently dealing with CPS and the police regarding the smoking marijuana deal.
So before I ask her about that, if all of these concerns are true, why did you agree to a week on, week off parenting time schedule?
I never did, Your Honor. I first agreed to that way back last year, right after my mom had just passed away. I was in an extremely emotionally vulnerable state. I'm an only child. She was a single parent. And I feel Ms. Hughes kind of manipulated me during that time. It took advantage of that. And so apparently did the referee, which is why she switched it back. I have had full custody since 2013.
July 31st of 2019, you entered into a stipulated order providing for joint physical custody of Turner, Kaylee, and Cadence.
That was a month after my mom had died. Yes.
A week on, week off parenting time.
That ended up not working out, and she ended up trying to take me back to court for whatever other reason with the ref, at which time the ref decided that it was better off that it actually be reverted back to what it was before.
All right, well, so ma'am, are you smoking marijuana while you're driving the car that your children are in?
No, sir. And actually, the trip that he is speaking about, my girlfriend was in the car with me, whom does not smoke marijuana at all on any occasion. She hasn't in the last probably about 15 years. And it's just me. I smoke cigarettes. She smokes cigarettes. Neither one of us were smoking in the car. And it was me, her, and my 4 children in the same vehicle. There wasn't any extra person in the car with us. We were legally seated, and I was not even going 70 per the whole trip because I was pulling a trailer. So I was going between 65 and 70 because of the trailer that I was pulling. So I find it very hard to believe that Turner would say that I was smoking weed in the car, considering I did not smoke weed at all the whole trip because I was pulling a trailer. I needed to be in my right frame of mind. I didn't even smoke before I left the house that morning or anything. I smoke weed when the children are in bed and I no longer have a obligation and I can chill and relax and have a moment to myself before I go to bed so I can sleep. I don't smoke when I drive across town. I am perfectly fine going a whole day without smoking. I don't have a need to smoke every second of every day.
All right. The concerns raised are legitimate concerns if they're true. I can't deal with those today. CPS can certainly deal with them. If CPS determines that there's probable cause to believe that happened, they will intervene and they will do something. But I am not changing the order that I put into effect. I expect it to be followed. I will make sure, sir, that you get a copy of it sent today. I expect, absent intervention by CPS, that the children will be transferred to their mother. I'm trying to remember when the exchange day is supposed to be.
They're supposed to be Sundays, and I tried to attempt to pick up on my Sunday this week because this is supposed to be my week of visitation, and he again denied me. So I'm in the middle
All
of my
right.
visitation week.
I'm gonna flip-flop the weeks. We will make the week begin on Sunday, ma'am. That'll now be your new week. Again, if CPS intervenes, I'll deal with that later. If some other kind of motion is filed, I will deal with that. But for now, I expect my orders to be followed. We'll make sure you get a copy, sir.
All right.
Perfect. Is there gonna be anything for makeup time due to me missing the last 2 weeks of my visitations with my children?
I may deal with that in the future, but I'm not gonna deal with it today.
Okay.
Shoot, I threw my docket away again. It's Tuesday. There it is. Okay, let's do Linux.
Morning, Judge.
Good morning, Mr. Conant. This is the matter of Lennox versus Hayworth. Ms. Lennox is slowly making a connection. And I just admitted Mr. Hayworth in. Are you the only counsel on this matter, Mr. Conant?
I am, Your Honor, to my knowledge.
Okay.
Who's he representing,
Go state your opinion.
Okay. Dennis J. Conant, P23340, appearing on behalf of the plaintiff, Rachel Nicole Lennox.
All right, and for some reason, I must have left this file in chambers. I'm gonna go see if it's sitting on my desk. Hold on.
Okay.
Well, Shannon's gonna run in there for me. All right, so I remember looking at this file yesterday. As I recall, this is the one where both parties filed objections to the temporary order. Is that correct?
I don't know that Rachel did. I don't think Miss Lennox filed an objection. I think she was satisfied with it.
Well, maybe that's a different file I'm thinking of. I know there was one up for today where both people objected. Let me. Took it back out to your desk. All right. And I'm sorry, who do you represent, Mr. Conant?
I represent Rachel Lennox, the plaintiff, Your Honor.
Oh, okay. All right. Shannon's still trying to find the file for me. I remember reading the objection, but I don't know what I did with the file. So, Mr. Hayworth, what were your objections to the temporary order?
Can you hear me?
Yes.
Okay. I object to the supervised visit.
How many children are involved here?
2.
And who have those children been living with up till now?
They've been living with Miss Lennox.
And how long have the two of you been living apart?
Since September of last year.
That entire time they've been living exclusively with her?
Well, they were coming over quite a bit for visits, but after Rachel found out about my new girlfriend, she kind of made that a little more difficult and then brought it to a stop.
And Mr. Conant, what are your client's objections to unsupervised visits?
Your Honor, first of all, there was a police report made out in regard to domestic violence by Mr. Hayworth's girlfriend that he lives with, and also Mr. Hayworth on my client. It took place in the presence of the minor children, and that was in January of 2020. And to the best of my knowledge, there's been no contact by Mr. Hayworth since that time.
Mr. Hayworth, you acknowledge the incident of domestic violence?
I acknowledge the incident. It didn't happen the way she explains it. And
did you face criminal prosecution for that?
me, no. The incident was actually between Rachel and my girlfriend. It wasn't between me and Rachel.
Oh, so you weren't charged with domestic violence? Was
No.
anyone charged? Was
I
anyone
think
charged?
my girlfriend Trisha might have been charged, but that's still pending in court.
And you're still living with this girlfriend?
No, she has her own place. We've never lived together.
All right, well, whenever there's an objection to a proposed final custody order, which is what this was, typically what I do is continue the proposed order as a temporary order, and I schedule the matter for a hearing at which I'll determine what form the final custody order will take. unless the parties are willing to agree on something other than unsupervised. I mean, one possibility is we could have an order that says, if the problem is the girlfriend, we could simply have an order in place that says she can't be there when the kids are there. Mr. Conant, do you know if a provision like that would be acceptable to your client?
I think that would be more acceptable to her. Perhaps she could just respond to that, Rachel.
I don't agree. I only agree with the supervised visits. And also, Judge, his name is he has not done a DNA test. And also, his name is not on the birth certificate.
Is there more than one child involved here?
They're twins, Your Honor. They're 8-year-old twins,
Oh, okay.
boy and a girl.
Well, there must have been a paternity determination made at some point.
Never.
An
Mr.
affidavit of,
No.
Hayward signed the birth certificates. He refused to.
I refused.
so there's never been a paternity determination? Is that what you're telling me?
Correct.
All right, well, hold on just a minute. I'm going to see if I can find this file because I remember looking at it yesterday. I must have misplaced it. We'll go ahead and you could take us off the record, Shannon, but I'm going to leave the live stream running.
I didn't see it, boss.
Yeah, but I know I had it. So maybe I covered it up with something.
So I haven't tried to contact you at all, huh?
I don't know why you did.
Because I know I had it in my hands yesterday. It just doesn't make sense that I know there were a few hearings that got canceled. I must have mistakenly grabbed this file with one of those files. All right, so here's what I'm going to do. I will have Dawn find a date for a custody trial. I will take testimony and determine anew what the custody order should be. And if there is an issue regarding paternity, I can certainly address it at that time. In the meantime, I'm going to leave the temporary order in place. But, sir, we'll try to get you a hearing date just as soon as possible. In the meantime, if the parties are able to work something out, that's fine. But if not, I will decide all issues at a trial.
Okay, I can email the front of the court proposed final order to the court if you'd like that. That'd be helpful.
Can you do that right now? Let me take a quick look at it.
Can we do that? Can we email this proposed order from home? Gotta check with my tech support here, Jeff.
Okay.
Probably I'm gonna have to wait till I get to the office to scan this, Judge, and get it to you. I'm
Okay.
I'm sorry.
All right. Well, we'll get you folks a hearing date that will be as quickly as I can get it scheduled, sir. In the meantime, I would strongly encourage you to take advantage of the supervised parenting time that you've been awarded. Okay?
Thank you. Your Honor.
Judge, they are not doing the supervised visits right now at the front of the court due to COVID.
Are they doing them at? Is there somebody other than friend of the court that you would approve for supervision, like a grandparent?
No,
What about your mom?
my parents don't want anything to do with Mr. Hayworth.
If you can think of someone that you would let me know.
Not my mom.
I believe the folks that observe parenting time are still doing parenting time. It's obviously at a cost. So what I will do is order that you take advantage of that. I'll get all of that out hopefully yet today. Somebody's giving us a bunch of feedback here, so whoever that is, if you could mute your microphone. Okay, so temporary order continues. Supervised parenting time at observed parenting time, and I will send you the information on that, and then we'll set a trial date, and we'll get to the bottom of this.
Very good. Thank you, Your Honor.
Thank you. I don't know what I did with that.
Probably just threw it in the downstairs box or something.
I probably did. I remember grabbing a bunch of files that got pulled off at the last minute.
I took a load of them down yesterday, so like a big stack, so I'm guessing that's probably where it was.
Probably. Okay, Fleming versus Lewis.
Don't ever doubt me again.
I was afraid I'd buried it under something. All right, let's see who's here on that. I just allowed a phone in, 9451312. What is your name?
My name is Stacy Fleming.
Stacy Fleming. Okay, hold on a minute. And I see another phone here. Okay, ma'am, on the LG phone, what is your name?
Hello.
Yes, what's your name?
Yeah. Priscilla Lewis.
All right, I got the right two people in here. Hold on a minute. Okay, looks like Judge McBain entered an ex parte PPO in my absence back on June 24th. And now, Ms. Lewis, you filed a motion to terminate that PPO. Is that correct?
Yes. Yes, sir.
Okay. Ms. Fleming, let me ask you before we go any farther, do you see any need for a PPO to remain in place?
Does it need to be remain in place?
Okay, so here's what we do. When there's been an ex parte PPO issue, that means without a court hearing, based solely on the allegations of a petition. When there is an objection filed, we go to an evidentiary hearing where I take testimony. And Ms. Fleming, the burden is on you to establish to the court that grounds exist for continuation of the PPO, okay?
Okay.
So here's how it works. I will take testimony from you first. I will give Ms. Lewis the opportunity to ask any questions that she would have. And then I would take testimony from her and I would give you that same opportunity for questions. And then I will make a decision, okay?
Okay.
All right, so I want to put both of you under
Okay.
oath right now. Would you each please raise your right hand?
Yeah.
Do you each swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Okay, I've got a yes from both. So Ms. Fleming,
Yes, sir.
uh, what is the nature of your relationship with Ms. Lewis?
Supposed to be
Cousins. And what is it that Ms. Lewis has done that you believe requires the court to enter a PPO?
a video. A video. My son posted a video of her brother on Facebook.
So you posted a video of
My
your
son.
son. Oh, I'm
My
sorry, your son
Posted.
posted a video.
Yes, sir.
Okay. What does that video portray?
This portrays that I don't know what took place. Only thing I know, they told me that my nephew had went to jail. What he went to jail for, I don't know. About a half an hour, I was sitting in the car, me and my daughter was sitting in the car, and they said they were the boys right there. So the boys came out in the middle of nowhere on a gray looking car. So we walked down. And I talked to one of the boys in the car. They said they come over there. They don't know why he went to jail. I was talking to one of the boys that was in the car. And so it got physical, argument. And, we thought they was going to fight. You know how black people, they pull out their phone. All of a sudden, her brother pulled out a gun and shot it at the boy. And so my son posted a video on Facebook. And he was talking about that. I supposed to say something in the video. And I was like, what I supposed to say? Then plus she was going around about she was supposed to meet my son if we come up to her job to get food.
So did she express to you she was upset about the video?
Yes, she was very upset about the video and about me going up on her job trying to talk to the manager. Yes, she was. She was very upset.
What you went to? I want to make sure I understand you. You're saying you went to her place of employment and talked to her employer?
Yes, want to talk to the manager. I want to talk to the manager, and it was a girl. She said she no longer worked there. She said, well, what you want to talk to the manager for? I said, well, it was regarding Consider Lewis. She said, well, she don't work there no more. I'm like, okay, then. She said, where was going? I said, well, she was going around telling people she was supposed to meet my son. So that night, when I got out of my car, I called my friend, Johnny, to meet me at the door. And he said, okay. So when I got out of my car to meet my friend, Johnny, at the apartment, Consider Lewis came out in the middle of nowhere, questioned me about the video and about her job. And I told her that she know her brother was wrong, pulling out a weapon on that guy. I told her I did go up there to her job to get some food, and I talked to wanted to talk to the manager. But like the employee said, she no longer worked there. So I left it as that. And she got physical violence about what she was going to do. She followed me to my friend's apartment. And kind of forced her way in, wanted to fight me.
She wasn't able to get in?
No, she was trying to, it was like one of them automatic doors. She was trying to pull open. She was trying to pull the door open to get in.
Okay.
And then her mom
And
came in the
that's-
middle of nowhere. Sir?
Go ahead.
And then her mama came in the middle of nowhere and asked me what was going on. I was, her mom was like yelling, what the going on? I was like, well, I don't know what really was going on. She said, well, what's going on. I was like, well, your son was wrong putting out a gun on this guy. And then her mom was like, well, that's your freaking imagination, blah, blah, this and blah, blah, that. So I left it as long. And then the police officer had called and let me know the police was outside. It was a mess. It was.
So other than this one incident where she came and tried to force her way into your home, has there been any other?
In my friend's apartment.
Oh, in your
Johnny.
friend's apartment, okay.
Yes, Johnny.
Has there been any other contact between you and Ms. Lewis other than that?
No.
All right, is there anything else you want to tell me?
That was it.
Okay, well, ma'am, based upon your testimony, because this is a non-domestic PPO, in order for a non-domestic PPO to be granted, there have to be at least 2 separate and distinct incidents. You've only alleged 1. I cannot continue the PPO. I'm going to have to terminate it. I would encourage the 2 of you just to stay away from each other until this settles down. I don't think either one of you needs that kind of frustration in your life. But based on the testimony, I do have to terminate the PPO. Thank you.
Thank you, Your Honor.
You're welcome.
Do I leave now, sir?
Yes, you're all done, ma'am. Okay. This is the matter of Page versus O'Dowd. Counsel, state your appearance, please.
Good morning, Your Honor. My name is Matthew Hotchkiss, appearing on behalf of Plaintiff Branda Page.
All right, and I see Ms. Page is here. Mr. O'Dowd is not, which is a little surprising because he comes to every hearing.
Your Honor, I know that I had spoken to Ms. Sherwood, Dawn Sherwood, and she had stated that Mr. Page may have some work issues, but I thought that they were resolved. So I'm not sure if maybe something changed in his work schedule now and he has made anyone aware. I'm not certain why that might be.
I'm going to check my email real quick just to see if there's anything in there.
Sure.
But he never misses a hearing.
Can you get me that PPO file, please? Just an order.
Oh, okay. I was going to fill out an order.
No, don't.
Because she put a blank one in.
Oh, okay. That's not a.
Yep. Oh,
Thank you.
I don't have anything about Mr. O'Dowd, Judge.
I do have something. Initially he asked for the date to be changed due to work, but then he called back and said he was okay. But he's not here. I can predict what he would say, so let me hear from you, Mr. Hotchkiss.
Thank you, Your Honor. So I've had an opportunity to review the court's previous orders, and I know that there was an order dated May 6th of 2019. And since that time, I know that Ms. Page has struggled, or prior to that time, Ms. Page has struggled with the parenting time. Although from my recollection of the file, the struggle was never with an interaction with Braden, the minor child, but it was with Miss Page's inability to maintain her sobriety. So since that time, and essentially all of the year 2020, Miss Page has been on the track to improve her life substantially. She's made me aware that she was in a home to help with housing, and now she's secured her own housing. She currently lives in Grant, Michigan. She drug tests. She's told me that all the drug tests have been negative, essentially. So she's taken the steps that she needs to kind of secure her life and to better it. So she's in a position now where I think that can ask for some parenting time. Essentially, Braden is 11 years old. So he's young enough where a bond can still be mended between him and his mother. And I know that in reflecting on the court's previous order, you had stated that that order would be her last chance before suspending her parenting time. So now, coming before the court, I think Ms. Page is in a much better position to begin the process of initiating some parenting time and securing that relationship with Braden. So what I'd ask the court is for an opportunity to have video calls, like we do Zoom, Skype, phone calls, maybe twice weekly with Braden, and then hopefully get some supervised parenting time. I had spoken to Ms. Page, and I know that some places, the Family Visitation Center, I think, is not allowing them. However, looking at a healing place, I know this court may have some hesitation in granting Ms. Page's parenting time, but with the healing place, the court would have an opportunity to have some reports and some feedback, on how Ms. Page interacts with Braden. And again, in my recollection of the court's file, there's nothing that says that her parenting time with him is negative, just that it was non-existent. So consistency is what Ms. Page is looking for, and consistency would benefit her, and I think Braden greatly, keeping in mind the best interests of Braden in parenting time. So what we would ask is that you grant that and allow her at least twice weekly video chats with Braden, and then one supervised weekly visit through a healing place at a place of your choosing, where they could initiate that. If the court is uncomfortable with any of this, I would be fine with appointing maybe a guardian ad litem. I know that because of the nature of this case and how long it's gone on, you're probably very familiar with Ms. Page and with this case, so maybe a guardian ad litem is not necessary, but it may be helpful in assessing how she interacts with Braden now. And then lastly, if we need one, then I'd be more than happy to have an evidentiary hearing on this issue with Mr. O'Dowd can be present, of course. So that's what we would ask for today, Your Honor.
So, Mr. Hotchkiss, let me educate you as to why my order from a year ago was entered.
Sure, of course.
I get that there are parents who struggle with substance abuse that make them unsafe for anything other than supervised parenting time. And typically what I'll do for someone who's struggling with substance abuse is some form of supervised parenting time. The problem here actually goes much deeper. It's when Ms. Page loses her sobriety, she disappears. And the problem is this child has gone through numerous disappearances by mom, and she'll re-enter for a while, maybe be consistent for a little while. And every time this happens, it breaks this poor child's heart. And then dad has to deal with the fallout from that. I have been very, very lenient with Ms. Page over strong objections by Mr. O'Dowd that it's just too hard on the child to see this happen. And he's the one that has to deal with it. So I remember how upset he was with me when I said, no, I'm going to give mom another chance. And I said to mom very clearly, ma'am, this is your last chance. You can't keep doing this to this child. And sure, no, don't interrupt me. Don't interrupt me, ma'am. And sure enough, it happened again. She went to jail again over her substance abuse issues. I'm not going to put this child through that again. I'm just not going to.
Your Honor, I am so sorry, but I just got a note from Miss Sherwood that she's got Mr. O'Dowd's phone number.
Oh, okay. What is that?
It's 517-358-8974.
Last four again?
8974.
Thank you. All right. I'm going to see if I, hold on, ma'am.
Hi, you've reached the voicemail of DJ O'Dowd. Please leave me a message and I'll get back with you as soon as I can. Thanks.
At the tone, please record your voice message. When you are finished recording, you may hang up or press pound for more options.
Mr. O'Dowd, this is Judge LaFlamme. Your case with your son with Ms. Page was scheduled for a hearing this morning. Trying to call you to get your participation. Obviously, we have to proceed without you. So, go ahead, ma'am.
Since I got arrested in July 2017, and I think this case started in like September of 2016, and I was doing visits prior to that. But Mr. O'Dowd was not taking the child to the supervised visit. Upon my arrest, I have never, this has been 3 years now, I have not left the child's life. I went to jail once, but prior to that, I had not missed any visits. You said it was your last chance because he stated that I missed 2 phone calls while I was in jail. That was because I was unable to make the phone calls. Other than that, I made every supervised visit, every phone call. I entered into evidence text messages where he denied phone calls over and over again. I mean, I have been there. I don't know where this disappearance is coming from because we went to counseling. I was there. We did supervised visits. I was there. I did phone calls. I was there. I have talked to him on Mother's Day and on his birthday. We talked for 2 hours. He misses me very much. He says he wants to see me. He loves me. I think about you all the time. In his room, I sent him pictures. He has a wall of pictures of me. a collage of pictures. He has about 30 Lego sets. The only one he has left put together by his bedside is the one we put together. Mr. O'Dowd has fabricated lies. I've been there. I graduated recovery corps. I have had one relapse since July of 2017. I have been there, Judge. This is like, when you said it was your last chance, I missed 2 phone calls. Yes, I take responsibility for that, but I was unable to make them in jail. He was denying every other phone call. Every other phone call he was denying. I'd have to call and argue with him about the phone calls, about getting my parenting time. I submitted to the court, this is in January of 2019, evidence that he had refused to make up a visit at the parenting center, and that he had denied 2 phone calls, and he was ordered to make them up. Yes, I did go to jail in the meantime of that, but while I was in jail, I was making weekly phone calls to him still. And when you discontinued my parenting time, he couldn't call me in jail. I was talking to him for a month in jail, and I'm trying to make not light of the jail situation, but not for him to worry about me. So when I was talking to him on the phone, and while I was in jail, I was telling him about Monopoly game we had won, that I had won. He goes, Mom, I wish I was there. I said, honey, this is no place you want to be. He goes, I don't care, because I would be with you. That's why I've hired an attorney, because I know that it's in his best interest to see me. He is not heartbroken. I'm sure he's damaged by this, but it's because the inability of Mr. O'Dowd to see that he wants to see me, that he wants to be in my life. I want him in my life. I feel like there should at least be a guardian ad litem, some investigation. You should talk to him or something before you just continue all my parenting time, because he wants to see me. He's not hurting. He wants me in his life. I guess that's
So,
it, Judge.
I am very, very reluctant to let you back in, ma'am. I will appoint a lawyer guardian ad litem. I'd like Mr. Mike Kelly to be the LGAL. We will have Mr. Kelly do an investigation and give a report and recommendations to me, and I will decide after I get his report whether I'm going to do anything at all to reestablish any kind of parenting time for the mother. I will prepare that order, Mr. Hotchkiss, and we'll make sure you get a copy of it.
Thank you, Your Honor. I appreciate that.
Have a good day.
You as well.